In this book here now, Pennsylvania Rules of Court, it's going to be 2002. Now, doesn't it make it very, very clear is that the case has to be started by the real party of interest? Now that you've been in a CRC now for what, four months or a couple months anyway, right?
Yeah, about a couple months.
Okay. So based upon what you have read, would you please tell us who is the real party of interest in this case?
It was an asset acceptance.
But how can they do that when they never had an assignment from Chase specifically given assets the right to file the lawsuit?
That's correct too, yeah.
So once again, Kevin, who is the real party of interest in this case? That it should have been Chase Bank, shouldn't have been.
Yeah, definitely Chase Bank
Right.
should have been.
Should have been. Guys, when you go into court now, it doesn't matter what state you're in, okay? What you all must do is go out and pick up your copy of your state rules of court. Now, this is ours now from our state, and would you please scroll in on this tighter so that they can get this, okay? Every one of you that are going to court should read this. If you want to win, if you want to have some fun, that you have to read this.
If you want to understand what the other side is doing.
Right.
So many people sit there and they just don't understand, can't comprehend what's going on. They don't know how to react and they just get steamrolled.
Right. Okay. Then what happened next now? Are the first words out of your mouth, what did you say first? Do you recall?
Well,
exactly.
When the lawyer for the plaintiff was...
What was his name?
Jason Arnold.
Okay.
When he was addressing the judge that he had some papers here from the bank, and he just went on for a few minutes, and I objected that to the lawyer.
So what type of papers now was he referencing?
They were papers which I didn't see them at this point. He said it was stating from Chase Bank that I had a loan with them.
Well, what documents did he have in his hand?
Well, once I saw them later...
Yeah, what were they?
It was two pieces of paper. One paper was a copy of a affidavit from a woman stating that she was from Chase Bank and notarized. From Chase Bank?
But who filed the complaint?
Asset acceptance.
Assets. Can't do that. Okay? So go on, Kevin.
So at that point, the other paper was just, in which I didn't see at that point, was he said it was another paper from Chase Bank stating that I had a loan. And at that point, I said, Your Honor, I object to this, that under Rule 319, in so many words, that when a defendant shows up and the plaintiff does not show up, that the judge, according to the rules of court, shall rule for the defendant with prejudice.
Okay. This rule now that he's going to read is taken directly from our rules of court. Okay. Now, more than likely, guys, this is going to be in your rule books all over the United States. Go out and buy your state rules of court. And Kevin, would you be so kind as to read what you read in court before Judge Heck? And this is Pennsylvania Rule 319.
Rule 319. Failure of a party to appear at the hearing. A, if a plaintiff who has been given notice of the defendant's intention to defend does not appear at the hearing, but the defendant does appear, the magisterial district judge shall enter judgment for the defendant or continue the case for cause.
Did you notify this Judge Heck that you were going to raise a defense?
Yes, I went there in person, or I could have mailed it certified, but being so close, a few miles away, I just went there, right to the district.
I want to ask you something now. When you went in there and told them that you were going to raise a defense, what was their attitude like? Were they shocked?
So I think they were curious.
That rule said that if the defendant notifies the courts that he or she is going to defend, and if the other side, like the bank, though, is notified that the defendant is going to defend, It states in Rule 319 that the plaintiff must physically be in court. Is that what it says?
Yes.
When you raise that issue with the judge, did you raise it with her?
Oh, yes, I did. I read it, and...
Now, wait a minute. You read it to the judge?
Yes, out loud.
And was the plaintiff physically in court?
No, just the lawyer for the plaintiff.
The lawyer. If you understand the rules, look, this is my beliefs too, that we will win.
We will win.
Okay. But let me warn all of you judges, then all you debt collectors, if you violate any more of my friend's civil rights, we're going to do these shows, and it's going to be all over the United States, right? Because we're sick and tired of you people lying to us. That I'm sick and tired of you taking advantage of this man here who has 7 kids. It's not going to happen anymore. So all we're asking of you is to follow the rules of court, that you won't have a problem with us. Yeah. And for all of you that don't, your face and your story is going to be on these shows, and it's going to be broadcast all over the United States.
And the judicial complaints will start going too, because you established the record in court, you established she had to follow the rules, and she didn't. Well, the Judicial Conduct Board needs to have a complaint filed against her for violating her contract. She breached her contract, breached her fiduciary duty. She pretty much threw her oath out the window.
And Jim,
and she needs to be charged.
Knowing me, do you think I'm going to carry through with that?
Oh, definitely.
And knowing you, that if I don't, that you're going to be doing it yourself.
That's right.
So what did you raise with the judge? What exactly was the first sentence that you can recall that you stated to the judge?
The lawyer just kept talking and talking for a few minutes about alleged evidence. I interrupted him and I said, Your Honor, I object to this.
Okay.
You can't keep talking about alleged evidence unless it's entered into court.
Did you specifically ask this Judge Heck, where is the plaintiff? Is it safe to assume that the plaintiff will not be appearing in court?
Yes, I did say that after.
And what did Judge Heck say at that particular point?
She said that the lawyer is representing the plaintiff.
Imagine
attorney
that.
Cannot act as an advocate, though. So
Right.
anytime he talks, he's testifying.
What did you say then to the judge?
Well, after I stated Rule 319, she right away said, well, she's going to have to recuse herself.
Yeah, she's stepping down.
Right, she said she's stepping down. She's going to have another judge do this case some other time.
What did she do then after she made that statement?
Well, first the lawyer said, well, what does that have to do, recusing, with this case?
Right, because he was worried about that she might be a little bit too honest for him.
Yeah.
Right, go on.
So the judge got up. She said, excused herself, stood up, turned around, and opened a door that was right behind her that led to where the court secretaries were working in an office. And she went back in there for about 5 minutes while we just sat there.
And do you know exactly what this judge did when she was in her office for 5 minutes?
I don't know what she did, but just a common sense thing was she must not know what to do. She's going to try to find out what to do. I thought the case was over because she said she was going to recuse herself.
Here we have a judge there that's never had a guy in court that asked her, is this court governed by the rules of court? Is this court governed by the rules of evidence? What's this guy saying? Do you know why? Because they can't answer the complaints, Jim. They can't answer our preliminary objections because the truth is on our side and they know now that they've been had. So when the judge came back in, what was her demeanor like?
Well, she came walking in fairly brisk, and she says, hey, there's a new recent rule.
New recent rule. Right, so where did she get this new recent rule from?
Well, I know she didn't have it before she left, so she either had to look it up or make a phone call.
So that tells me this, guys, that at least the Pennsylvania bar, if not the American bar, is now teaching our judges what to do with people like you and I.